Hey out there, legal warriors. 3 critical mistakes for you or your defense attorney to avoid in defending a criminal charge. Are you interested in the criminal law? Does this apply to you? If so, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I've been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. In my opinion, there are 3 critical mistakes that defense attorneys can make and that clients can make when they're trying to either work on their own case or get their attorney to work on their case for them. Now, what are those 3 mistakes? I think the first one is talking to the prosecutor too soon. Now, I've covered this in other videos, and I was a prosecutor for 7 years, so I know quite a bit about this. Here's how the criminal system works. Somebody gets charged with a crime, they get arraigned on the charge where they say not guilty, then there's pre-trial hearings. 1 pre-trial, 2 pre-trial, 3 pre-trial, etc. So for a couple very important reasons, it's important in most cases to not negotiate with the prosecutor too soon. The first of those reasons is because a prosecutor, it's not their job to let the defendant go. It's their job to respond to the case in some way, and when they're asked to respond too soon in the case, it's more of a risk on them, right? What's in it for the prosecutor to let someone go? Not a lot, right? A prosecutor has a boss, they have someone that's employed them, they have maybe a victim or police officers that want to see a certain thing happen. And early on in the case is when the prosecutor is sort of the most maybe uptight about the case, most worried about the case, most shocked about what they saw in the report. And it's human nature, as time passes, they can relax some about what's going on. And as time passes, also the defendant becomes a better risk, because as time passes and nothing else happens, hey, there's more to show that maybe this was a one-time thing. So if you try to negotiate with a prosecutor too soon, that might be at a time in their mental head where they're the most upset about the case and more likely to say bad things to the defense attorney about the result that they want to see. The second reason why you don't want to negotiate too soon is the prosecutor's not used to it, right? The system is set up where they're trying to deal with cases maybe 4 months, 5 months, or 6 months down the road. They're thinking in their head, hey, the judge at some point isn't going to allow any more continuances, so I might have to spend my entire weekend preparing for a trial if I really hold the line on this case. Or maybe I need to get a little more reasonable to find a resolution, because I can't take these 15 cases that are super old that are set for trial this time. I can't take them all to trial. I can only get 1 jury at a time. So as time passes, that's when the prosecutor thinks, hey, these are the old cases, I need to look at those, because the prosecutor has limited time, right? Everybody in the criminal system is overwhelmed right now. They were overwhelmed before COVID, and after COVID, it's even worse. Just think, cases after case after case after case got charged during the period of time the courts were closed. So the courts are closed, more people keep getting charged with crimes, but there's no way to resolve them. So this huge backlog is out there. I'm filming this in November 2022, and now is a real rough time for prosecutors. So the first big mistake was negotiating too soon. The 2 reasons are, early on, the prosecutor's pretty uptight about the case, pretty mad about it. And also, if it's too early negotiating, they're not used to that, and they probably won't even listen to your defense attorney. So I think that's the first big mistake that you can make, is negotiating too soon. So what's the second big mistake? And this one is also counterintuitive, and that's why I'm putting it out there. It relates to some other things I've covered in my videos, but let's just say it like it is. Sometimes it's a mistake to actually interview witnesses. If you have lay witnesses, non-professional witnesses for the prosecution, victims of assault, victims of theft, something like that, we think from watching TV, well, we need to go interview that person and catch them in some lies and have them make some mistakes. And that may be true at the felony level. We're going to need to do that at the end because it's hard to negotiate felony cases. But at a misdemeanor, a gross misdemeanor level, assault 4, theft 3, those type of things in Washington State, as time passes, it's safe to assume in many, many cases that whoever the alleged victim is has other stuff going on in their life. And if your defense attorney goes out of their way, or their investigator, to just go interview everybody as part of doing the case, it really may reactivate their interest in the case and may make them reach out to the prosecutor and say they want bad things happen to the defendant. So again, think about it. The prosecutor is looking for a way out of cases, hopefully, at eventually a way that's reasonable, a way they can respond, and because not every case can go to trial. And if an alleged victim is chirping in the prosecutor's ear about terrible things they want to happen to the defendant, what do you think the prosecutor's going to do? Are they going to be more lenient, or are they going to be less lenient? Less lenient. So oftentimes, it may not be a good idea to go interview adverse witnesses. In fact, we hardly ever do it in my firm. And if anyone's looked at my firm, you can see the type of results that we get. When a case gets towards a trial, if we really cannot get anywhere, we may be forced to do that. But that should not be a first approach, in my opinion, on non-felony matters, at least in Washington State. So I think the third big mistake, the third critical mistake one can make, is just not doing any type of classes or education to help your own position. So many people might believe that if you do some type of anger management class or theft awareness class or alcohol and drug evaluation and treatment, that somehow that's an admission of guilt. You know, I didn't do anything wrong, why should I have to do that type thinking? Well, number one, it is not an admission of guilt. It cannot be used against you. And number two, whether you did anything wrong or not, the goal is to get out of the case. The government is all powerful. As you've heard me say before, the truth will not save you. There is no absolute truth. The prosecution has their truth, defense has their truth. So it's important that you do something so the prosecutor can find a way to feel emotionally that they've responded to the case. If a client's done an anger management class, or client's done a theft awareness class, client has done counseling, well, we can tell the prosecutor, hey, you know, my client, although they're innocent, has been responsible. They've taken some education to look at whatever part they played in this, and now let's find a way to let them go because they have done something. Just think about it. If you are a prosecutor and this defendant has done nothing, and some attorney is saying, dismiss the case, it's not your job to dismiss the case as the prosecutor. It's your job to respond to it. In a case that has got amazing defense issues, yeah, the prosecutor may be forced to dismiss the case. However, sometimes a prosecutor will still dig in their heels and you might be forced to go to a jury trial, which will be stressful, expensive, and do we really want to let 6 people who didn't get out of jury duty decide what happened? I'd rather not if I could control the outcome. So those are 3 critical mistakes to avoid. Please don't rush negotiations. Don't do that. Don't go interview witnesses right away in most cases. And finally, don't just do nothing to help improve your position while you're waiting for this case to resolve. So if you found this useful, please like and please subscribe. More people will get the help they need. And more importantly, if you've got some type of legal problem, if you need help with a criminal case in Washington State, feel free to reach out to my firm. We've been defending people charged with crimes for more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.